Hey everyone, Dan McKenzie here with the McKenzie Law Firm in Denver, Colorado. We do estate planning, estate administration, and small business counsel. Wanted to touch on an issue today that we run into a lot with clients, and that is that they equate a will with having an estate plan. And so they figure, well, if I don't have a will, I don't have an estate plan, and if I do have a will, I do have an estate plan. And actually, your will is one part of an estate plan. And you're doing a lot of stuff all the time, actually, that would bear on who would get your stuff, who would take care of your affairs if you couldn't do it. And again, a lot of people are thinking about death. There are other situations where you might need help. So there's just a lot more going on than most people realize. But typically, your estate plan is actually a mix of things. And so the way I describe it actually is you've got a number of different tools available to you to transfer assets to other people if you pass away. And so one of those tools actually is owning things together. So I'll say asset titling here. What I obviously mean is buying something jointly. And there are different ways to own things together with people. You could each own half of something, for example, a business or even a house. Just because you buy a house together does not necessarily mean you both own the whole thing, legally speaking. But the default on most situations is that if you buy a house, especially with a spouse, which is the most common way to purchase a house with someone else, you own that together. And if one of you passes away, the other person is going to assume full ownership of that house. Like I say, there are nuances to that, so don't make any assumptions there. Some of the biggest problems we see in probate is where people assume that was how things were set up, and it was not. So be careful about that. But joint ownership is actually an estate planning technique, and so that is one way that this will happen. And then number two is your designated beneficiary instructions. So these are most common on life insurance and retirement accounts. Typically, when you buy life insurance or if you set up retirement accounts, during that process, the company that you're working with will ask you who should get this if you pass away. And the thing to understand about that is that is a contract with that company. They don't actually care if you have a will or do not have a will. They don't care if anybody is unhappy with that will or whether there's going to be a probate or not. I mean, actually, that's one of its benefits, especially life insurance, is that we kind of want that money out quickly. And if things get bogged down in some sort of creditor claim or an unhappy beneficiary of an estate who's pursuing some sort of contest in probate, we don't want a life insurance policy tied up for years because that really might be needed immediately to cover last expenses, maybe medical bills, or maybe mortgage or ongoing expenses that are continuing despite the person passing away, of course. So for better or worse, the life insurance company, the retirement custodian, they're going to follow your instructions. So it's always important to make sure that those are up to date and consistent with what you mean for them to say. And you can put designated beneficiaries on a lot of things, actually. So like I say, it's part of the process of getting these things. But actually, in Colorado, for instance, you can even put a designated beneficiary in your house. But bank accounts, cars, actually, you can put designated beneficiaries on those too. So that can be a very effective and fast way to get things to people if you want them to. Again, caution. Those beneficiaries transactions are immediate, and if you leave things to like a small child or somebody who's receiving disability income or some other income-based need-based support from the government, you can cause them a lot of problems actually by naming them as designated beneficiaries. So you gotta be careful with that too. Number three, I'm gonna put entity. And that could mean a business. It could mean a trust. I will do a separate video on trusts. But your business, a business is going to be more familiar to most people. Obviously, you set up a business. One reason you do that is so you can put assets in the business, for instance, a bank account. So like the McKenzie law firm, my law firm, the bank account has, the checks have the McKenzie law firm on it. I am signing on behalf of the McKenzie law firm. And so, you do that for asset protection reasons and tax reasons and other things. So, but the point being, I have an operating agreement for the McKenzie law firm. It's going to control where things go if I pass away. And so there usually are instructions in there. If you don't have an operating agreement or some other instruction about how things should go if you pass away and you're the owner of your business, there are state statutes that will control that. And trusts are similar for personal assets. You title assets to your trust, and then you have a trust agreement. Your trust agreement controls where the things go that you titled to your trust. So that actually is the reason people do that, is to make it easy. Sometimes that works and sometimes it doesn't. Okay, and then 4, here's where your will finally shows up. So again, you may have thought I was detailing everything besides the will, because how could a will be this low on the list? And actually it is. It's there to deal with things that you didn't deal with up here. So anything that you have titled by yourself that does not have a designated beneficiary instruction on it. But for a lot of people, that actually can be nothing, right? If you're married and you co-own everything, or your spouse is your designated beneficiary, if you pass away before your spouse, everything goes to your spouse. So up here in 1 and 2, and your will actually does not control anything. So that happens quite commonly, actually. But a lot of situations where it's really a mix of these things going on. I might have co-titled some stuff with a spouse. I might have designated beneficiaries with my kids. I might have put some stuff in a trust, and then there might still be some stuff out there that didn't get taken care of by any of those steps. And when that happens, your will controls that. And then, of course, there are situations where it's the opposite. The will controls everything because the person passed away. They didn't really have anything. They were single. They didn't have anything co-owned with anybody else. And, they either didn't fill out designated beneficiaries or just didn't have any of those types of assets. And in those situations, the will controls everything. So, again, your will is not your plan. Your will is part of your plan. Okay, so that's really my primary point. And then if you don't have a will, what happens? Well, that's where state law comes in, and it's going to control where things go. And so, again, you could have a will, and your will might have some sort of drafting error, I would think, if it got down past there. But you could have things get all the way down to state law. I mean, I could probably come up with a scenario where every single one of these gets implicated. All of these could be used. But this is kind of in order of how things go. And then the last thing, again, that people probably aren't thinking of as an estate planning technique, because it's not very romantic, but it's true, and it's overshadowing all of this, is marriage. And so, marriage is, I guess some people feel like it's kind of an old institution that doesn't really have any practical applicability to today's situation, but it still matters in the estate planning world. Marriage, and the reason I say that is because in Colorado, at least, and a lot of other states, your spouse is the only person you actually cannot cut out of your will, at least not without their written permission. So, and other things too. Your designated beneficiary, again, if you've signed up for a 401k, you have to name your spouse as your beneficiary. And if you don't want to do that, you have to get their written waiver on that. So getting married is an estate planning decision. I think it used to be a much bigger part of the marriage decision than it is now, but it is still very important. So your will is not your plan. Your will is in the plan, but it's not the plan. And so it's just very important to understand a estate plan is actually a number of things coming together, and a will is one of them. So I hope this is helpful. Feel free to contact us if you have more questions about this. Again, we're the McKenzie Law Firm in Denver, Colorado. And thanks for watching.